Hello students, welcome to ABHI Law, where law is simplified. This is your Professor Dr. Ambarish R Patnigere, and in our lecture series, today we are going to start a new lecture on Indian Evidence Act 1872. And as you know, our lectures are quite important for those who are doing LLB and even for judiciary exam. I am going to explain this act section by section. It will be a little long, but definitely I will try to cover each and every section. Let's now start with our video lecture number 1 about introduction. In this introduction video lecture number 1, we are going to talk about the background of the Indian Evidence Act 1872. The ancient India, when we talk about in the background, are divided into 3 phases. The ancient India, then medieval India, and the third one is the British India. In the ancient India, we know that India was basically ruled by other kings, the kings which were having Hindu religion, and this is called the Hindu period. Hence, in this ancient India, the background was like this. There was the Dharma Shastra, Smritis, and many other Sanskrit books, according to which the evidence is to be taken care of. This theory is available, but the practical procedure followed were missing. Now, there was certain kind of evidence which were seen taken in the ancient India. That was Lekhya. Lekhya means documentary evidence. Another type of evidence was Sakshi, means witnesses. And the third was Bhukti, which means possession. The king was the judge and the dharma was the base of justice. Now, after the ancient India went on, the Mughal Empire invaded India, and now the Mughal rule started, which is called medieval India, where Hindus and Muslims both were staying together. Both periods were together. Sir Abdul Rahim, the principle of Mohammedan jurisprudence, which lecture series is converted into a book, talks about Quran was the base of the evidence that time when Muslim kings were ruling. There were oral and documentary evidence. The Hanif law understood evidence as, the first word was tawar. Tawar means fully corroborating evidences. Then was ihad, testimony of a single individual. Next was ikrar, admission of confession. And the last was karina, means circumstantial evidences. Now, after the Muslim period got over, Britishers invaded India, and in British time, the Evidence Act took a major development. In 1726, the rules related to evidence existed in England under the common law, and the statute were introduced in India. Nearly from 1835 to 1855, as many as 11 acts on this was enacted, means whatever act was there in the British, in the England, was not directly getting applicable to India because of the background, religion and other various religious books. In 1868, Sir Henry Somer Mane drafted an act which was found again unsuitable. In 1872, Sir James Fitzjames Stephen prepared the Bill of Evidence Act and presented it in British Parliament. The bill contains set of rules, regulation which governs the admissibility of any evidence of the court of law. The same was then implemented in India. Till then, there were different practices in different places for different people. After the implementation of the Indian Evidence Act 1872, the concern of admissibility of any evidence in the court of law was totally changed. Sir James Stephen is also known as the father of this act. Now we have understood the background. Let's look to the nature of the Evidence Act in our video number 2. Thank you. If you liked my video, please subscribe it. Please share with others, and don't forget to press the bell icon. Your subscription is our motivation. Thank you.